Good afternoon, and if I can just ask one question of Judge Fleming. Okay, thank you. All right, we are Division 6, and I am Judge Karen Ashby. I'll be presiding today. To my right is Judge David Furman. To my left, Judge Terry Fox. And we have one matter on the docket today, People versus Tresco. It looks as though both counsel are here and ready to go. And is that a drink on the table, Ms. Staley? If you could put that away, please. Maybe if you could just set it back on the bailiff's. Thank you very much. And I know that both of you have argued many times. In fact, you've argued before this division before, so I think you're both familiar with the rules and procedures related to oral arguments, so I won't go over those with you, but if you have any questions, please feel free to ask. Otherwise, we will get started with People versus Tresco.
May it please the court, counsel. My name is Katayun Donnelly, and I represent the appellant, Mr. Gabriel Tresco. We are here back after a limited remand, and I have received the questions that the court has asked the parties to respond to. Before I answer the questions, the overall position of Mr. Tresco at this point, based on what happened during the limited remand, is that he's entitled to a new trial with the assistance of conflict-free counsel. The reason for the limited remand was the fact that in 2015, when Mr. Tresco asserted his right to fire his then counsel from the Office of the Public Defenders, the trial court did not follow the established case law and did not observe its duty to hold a hearing right there and then. We have argued, and we still continue to argue, that the failure to do so was a structural error. And what happened during the limited remand is the best illustration of why those errors are structural, and the limited remand after 2.5 years, 3 years, is not an answer to violation of the constitutional rights when we are talking about the assertion of right to counsel. And as it became clear, in addition to the right to counsel, what Mr. Tresco would have said if he had gotten the opportunity on that morning during the trial was that he was going to assert his right to testify. And that is the part that has changed the posture of this case completely.
Well, Ms. Dunn, let me interject, because back at the trial itself, he had indicated filing a grievance. Isn't that what started the discussion on all this?
Correct, Your Honor. That is one of the things that was mentioned.
Well, let me just make sure I understand that record. There was no indication of, I guess, a Burgerud kind of a, I'm at an impasse as far as what the defense is saying, having to go pro se, all those kinds of things. There was some kind of a claim of a breakdown in communication.
So I wanted to highlight the fact that one of the critical problems with this process is that when the defendant raises his hand and say, I want to fire my attorney, my understanding is that to this day we are not giving him the conflict-free counsel that he's entitled to, as any hearing that is held the moment that the defendant raises the issue of firing counsel, that is still a critical stage of a criminal proceeding. And what is happening regularly is that the court is going through the hearing without having counsel present, which is why there is this disproportionate focus on Mr. Tresco's pro se, and I would like to emphasize that word, pro se grievance to the Office of Attorney Regulations.
Can I get clarification maybe on what you're saying then? Are you saying that once the issue of this disagreement with counsel arises, that makes it difficult for the defendant and counsel themselves to together raise the issue in the way that normally counsel would advocate on behalf of the defendant in front of the court, and so that's why then responsibility shifts to the court to make an inquiry and figure out what is driving the alleged conflict and attempt to resolve what it is the defendant is requesting at that point?
Exactly, Your Honor, because as we have discussed this, and that is why I have mentioned the moment that Ronquillo came out, I cited it in our supplemental briefings here before we went on limited remand, and I have cited it since every step of the way, that Ronquillo exactly addresses that issue, that we have all these bodies. We have Bergerud, we have Brown, we have Arguello, and all of them have been addressing different parts of this problem that we don't know. When the defendant says, I want to fire my counsel, at that point, nobody knows what the reasons are. And by virtue of raising that issue, there's that conflict that is arising. And by nature, the public defender is in this position that they have to explain their position, and nobody is now representing the defendant to explain. So what happened was when we went back on remand, Mr. Tresco had his counsel. So we have Mr. Tresco represented by counsel asserting his rights as explained under Arguello and asking the court to please follow the steps that I would like to assert my right. And the reason, and at this point, again, I'm highlighting the fact that he's for the first time represented by counsel and able to explain in legal terms what his problem is.
But on that, or during that limited remand, the remand court, obviously heard from all the parties and reviewed the grievance. My take on what the court did was, it said, anything that was in that grievance is believable. Anything that you add to that grievance is after the fact, post hoc rationalization. You're trying to improve your case. So why shouldn't we accept the credibility determination that the trial court made, whether it's explicit or implicit?
That is why it's a structural error. Because the court took away Mr. Tresco's right to explain there and then so he would not be second-guessed when he came back with counsel. If he had had this hearing in 2015, he would have said what he had said, and which has been consistent, by the way. Fortunately, we are fortunate in this case that
That's not what the remand court said. The remand court said that he's improved on his reasons for why he wanted to fire his counsel.
Of course, Your Honor, because he was represented by counsel. He was not pro se as he was writing his grievance days before this issue came up on the day of trial. Again, the timing of that is important. The grievance was filed days before the trial. Up until then, he didn't know. The PD had not even told him that they were going to go ahead without having the main witnesses in his case, that's the heat of passion, even present. The PD testified that up until that morning, they had not talked to any of the witnesses, knowing that this is a case that the star witness on the prosecution side had known Mr. Tresco and his family for over 20 years. And what was the theory of defense that they went forward with? That the star witness did not identify him correctly, which did not make any sense under any scenario. So when we have the problem, and that is what you're saying, is exactly the part that kind of turns our system upside down. So we have now, before our eyes, our adversarial system turned into a civil law system when the judge is acting as a prosecutor and investigator. In this case, without knowledge of defense, it was the judge who had directly contacted the Office of Attorney Regulation to get a copy of the grievance, which is unprecedented. So we are having determinations done by the judge and then allowing the prosecution inside the courtroom. But all of these, fortunately, under the facts of these cases, are irrelevant. So answering your question.
Sorry, I'm interrupting. Ronquillo was talking about a retained counsel case. I mean, that was a retained counsel case. Is there not a difference?
The only difference is as to the good cause piece of it. What Ronquillo did, fortunately, and if I were on one of the trial judges, I would be extremely happy to have Ronquillo as a guideline, because Ronquillo tries to resolve all of these issues by providing guidance in one opinion, going step by step. If you're sitting there as a trial judge, what do? The defendant raises the issue of firing counsel. The first step is to ask the question, why are you firing your counsel?
But if it's a retained counsel, that's a different question, isn't it?
Correct, Your Honor. If there is a retained counsel, the issue there was that, of course, as long as the defendant is in custody, they're also entitled to having the PD. So the question was...
But let me interject. So if it's a counsel of choice question, if a defendant is denied counsel of choice, not appointed counsel, that might raise to the level of structural error, right?
That also, but actually more importantly, is a case that we have right here, that in McCoy, the majority of the Supreme Court of the United States, Justice Ginsburg writing it, specifically says, in a case like this, when you have the defendant saying that this is my theory of defense, I want to testify in my own trial, there is no discretion at this point. Neither the court nor the PD nor any other counsel, whether appointed, non-appointed, retained, coming out off the street, nobody has a say in that scenario. It is only the defendant who can decide whether am I going to assert my right and exercise my right to testify. And Mr. Tresco did it the moment that he got the opportunity to do so.
So I'm interrupting you again,
Sure,
sorry.
no, please, thank you.
But if there's a question about a conflict, it may be that a judge determines, I don't think this is such a breakdown where you are effectively denied counsel that the conflict is not that significant. That's a fact question.
That is a fact question, but the question of asserting the constitutional right to testify is not a fact question. The moment the defendant asserts that right, there is no discretion on behalf of the court. It doesn't matter what the observations are because the credibility part is irrelevant. There is no question that in this case, up until remand, Mr. Tresco did not have a single opportunity to tell that court when it mattered and the hearing should have been held under the established case law by the Supreme Court, that I am asserting my right to testify.
Ms. Donnelly, I want to ask a different question because I see your time is running low. Even if I know you disagree with the court resolving the good cause issue and finding that there wasn't a conflict which required new counsel to be appointed for your client. With respect to the issue of whether he should have been allowed to proceed pro se, that wasn't an issue that was addressed on the remand because the court saw that the remand was fairly narrow. If this case were to go back, both you and the trial court have recognized the difficulty in trying to reconstruct or basically construct a record that was never made in the first place after the fact. How do you see this happening if the case were even to go back for a remand to address the issues that you believe needed to be addressed that weren't?
So when we were proceeding, we were just talking about the framework that Ronquillo should apply. And in that sense, our position is the same, that no matter what the case is and what the facts are, the court has an obligation to follow Ronquillo. When we got into the actual statement and assertions of their rights, in this case, the other arguments, the second prong, which is If you do not get the conflict-free counsel, appointed counsel, then what happens? Whether you can go ahead and hire your own retained counsel or represent yourself pro se, those are the two other options. However, in this case, based on the existing conflict, Mr. Tresco's position remains that he has a right to conflict-free counsel in this case, based on McCoy, based on Arguelles, and based on Bergerud's language, that he has a right because of the irreconcilable differences between him and the PD. These are facts.
My question probably wasn't very clear. Not if it goes back for a new trial, but if it goes back to a remand court for additional findings, recognizing the challenges that the trial court and both you have said exist in trying to construct that record that wasn't constructed in the first place, do you, in terms of what it is the trial court's going to rely on in terms of making findings, what do you expect that to be?
Unfortunately, the trial court's position has been that whatever Mr. Tresco says now, I don't believe because it is after the fact. And that is a problem. That is a structural error, that we are dealing with a system now that is not believing Mr. Tresco what he says, even though we are, at least the idea was to go back and construct, but we are not constructing anything because the trial judge's position is that I don't care what you're saying, Mr. Tresco, whatever you say is now after the fact. So nothing is going to help the court now. We have the record that we have, and on this record, he's entitled to new trial with conflict-free counsel. I have about 42 seconds.
Do you believe it's appropriate for the court to consider credibility of Mr. Tresco's testimony regarding what his request would have been? If not, why not?
So that was the issue that we were having, that if you're there in December of 2015, the grievance would be irrelevant because he would have the opportunity to explain what the conflict is. And what the conflict is that I want to testify. If the defendant asserts his right to testify, why does it matter if in his grievance he didn't mention that? The only reason now that the court, and that is a problem that we have had, that the limit, so Mr. Tresco has gotten divorce of both sides, that he's back after 3 years. Once and for all, I mean, having a second remand while he's almost has served all of his time is a travesty.
Right. And I apologize, but your time is
Thank you.
finished. Thank you.
I hope that I will get my 40-second for the rebuttal.
It's fine.
Mr. Lee?
Thank you, and may it please the court. John Lee on behalf of the people, bar number 38141. I plan on answering the pre-issued questions that this court asked us, but if I may, I'd like to begin with what I think is the prefatory question, which is what this court would have to hold in order to ask those questions. And that is the court would have to agree with the defendant that Ronquillo sets forth a framework that applies not just when a defendant is trying to fire retained counsel, but applies to whenever a defendant asks for substitute counsel as well. And in my view, that is an unwarranted extension of Ronquillo, and that would be an unprecedented holding. To kind of put this in the proper legal landscape to hopefully make this claim, kind of highlight what actually is at issue here. If this court looks back at Arguello, 772 P. 2nd, 87, Supreme Court on pin side I think is 94, explains that ordinarily a request for new counsel is not a waiver of counsel or a request to go pro se. It then goes through all the old cases, which goes back to the presumption that courts want to encourage defendants to have attorneys. So normally a request for a new attorney is not a request to go to pro se. We then get to Bergerud. Bergerud was a unique factual case, but if this court looks at footnote 9, the court explains that because it was an issue in the case, it wasn't going to address it, but it did note that it cites a bunch of law, how the general rule is in order for a defendant to claim that the trial court erred in not allowing him to go pro se, it must have been raised unequivocally and timely. It cites federal law and also cites this court's opinion in People v. King, where this court held exactly that. That in order for a defendant to later raise a claim of pro se, it must have been raised unequivocally and timely before trial.
Mr. Lee, can I ask you a question then? isn't part of what this whole area of law has tried to develop is a framework that puts some responsibility on the court so that the defendant can be properly advised as to what options he or she has when they're not satisfied with their counsel. And so you're saying, you're kind of, to me, putting the cart before the horse, which is a defendant would have to say, I want to proceed pro se, even before they might know that's an option available to them. So isn't that the purpose of having the colloquy between the court and the defendant to identify what's the problem, what is it the defendant wants, what does he or she need to know in order to resolve the problem, and decide what it is they want to do in light of what they're requesting? So if you don't have that colloquy, how can you hold it against the defendant that they don't speak up and advocate for one of those options that they may or may not even know exist?
And I'm trying to underscore that case law, that Rocio is the outlier, and case law generally and policy has always gone towards the opposite. So what's driving these decisions is a court, and I think it goes back as far as McCaskill and the U.S. Supreme Court saying, we want defendants to have attorneys. They're going to be better served if they have counsel. Although we have found a limited right, if they really want to, that they can go pro se, the general presumption is a defendant should and can have counsel. So Ronquillo creates a different and separate issue, because in that case, again, when a defendant is firing retained counsel, and if they're unable to qualify for court-appointed counsel, it raises the issue that maybe they will have to go pro se.
But
So before
Ronquillo-
terminating,
But Ronquillo wasn't pulling things out of thin air. It seemed to me Ronquillo, even though it was in the context of firing retained counsel, was trying to synthesize all those different pieces that were out there, whether substitute counsel should be appointed, whether pro se, whether you're going pro se, and it tried to set up a framework for trial courts to follow just generally when a defendant wants to fire their counsel, even though in that case it was in the context of retained counsel, it was building on law that already existed.
and I would disagree with that assessment based on three basic features of the text. If this court looks at paragraph 14, where the court's giving a roadmap as to what's discussing, the court explains that, I think it begins with third, we then discuss what a court should do to ensure that a defendant understands and accepts the consequences of firing retained counsel.
It doesn't say retained counsel, though. In
It does in
paragraph
paragraph 14.
14, it says, so when considering a motion to fire counsel, in parentheses, however framed, a court should first ascertain how the defendant wishes to be represented going forward. So at least in 14, it doesn't say retained counsel.
Well, I would say, I would point to this, I think it's the second to last sentence where it does say third, where it does say, we discussed the proceedings a court should do, which I then look, when you look at the paragraphs the defense counsel is relying on, which is 41, I think paragraph 41 and through 43. The very first sentence in paragraph 41, again, refers to when a defendant seeks to fire retained counsel. These are the steps a court should carry out.
Okay.
So again, and then you get the steps that follow. So it's completely within the context of firing retained counsel. And the reason I began my discussion with Arguello and Bergerud and this court's holding in King, which then cites Harris, which discusses whether or not it's incumbent upon a trial court to engage in this kind of colloquy when a defendant asks to substitute counsel, and in Harris, this court said a court does not, is what the defendant needs. Not only does he need to show that Ronquillo said it applies to all situations, which I don't read it that way, but to such an extent that it was overturning that presumption in Arguello, that it was taking a stand contrary to the majority of federal courts that it cited in Bergerud, and that it was overruling this court's cases, which there's been many since, that have said that a defendant does have to equivocally and timely before trial raise a claim before a trial court's required to inquire further. And I don't see anything in Ronquillo coming anywhere near indicating that the court intended to do all those things.
Counsel, your opponent has suggested that it doesn't really matter what the grievance, our Attorney Regulation Committee grievance says. Do you agree, disagree, and why?
I think the grievance letter is critical to this case, especially as we argued in the brief. The trial court found, consistent with the order of the remand, that the grievance form did in fact contain all of the defendant's allegations at the time. So that really is the basis for whether or not there was cause for the trial court, as this court found, to have implicitly denied the defendant's request for substitute counsel. And within that complaint, in regards to the question of whether or not the defendant should have been appointed substitute counsel, there weren't good grounds. He lacked faith in his attorney. That was insufficient as a matter of law. In regards to this new pro se claim, the trial court found that it was critical that this Bergerud testimony claim was never raised in the grievance letter, which was a credibility determination, one that trial courts can, should, and do make all of the time, and is entitled to deference.
But Mr. Lee, isn't it correct that the trial court specifically said, based on its narrow reading of our remand order, that it didn't want to hear testimony regarding those issues, and it wasn't going to make findings with respect to anything but what it found was there good cause to have Ms., I'm sorry,
Atkinson.
Kettleson, what's her name?
Atkinson.
Yeah.
Atkinson, thank you, withdraw. And it said, it even went so far as to say, it may be that the Court of Appeals has to send this back for additional findings if it wants me to address these other issues. So do you disagree that it did not specifically address those other issues?
No, that's absolutely correct, Your Honor. So I guess that kind of segues into some of the questions that this court asked, which is, can this court remand, and what could it say, and what should it do? I will say principally, again, our first position is what I argued previously, which is just that this court can't say that or should or shouldn't do that, just because under case law, it's too late. But as to whether or not the court could remand and what it could do, the trial court absolutely did not issue a specific factual finding on the pro se claim. It read it outside of the remand, and under the case law we cite in the supplemental. I mean, I think that is correct. But as to whether this court could rule on it without a remand, defense counsel acknowledged, and I think the trial court's findings are very clear. Although it didn't make a specific finding as to the pro se claim, it did find that all of the defendant's complaints were contained in the grievance form. And it did find that the defendant's later testimony, including the predicate to this pro se claim, that the reason for the disagreement was that he wanted to testify, but his counsel wouldn't let him because she wanted to pursue a different theory of defense. The trial court did find that not credible. So to the extent we have any implicit findings, so if the court just wanted to reject the pro se claim, I do think there is sufficient finding. To the extent this court doesn't feel like that is sufficient enough on that in respect to that issue, then it could remand for that finding. Other considerations I think a court would have to consider, should it remand on the pro se issue, and again, assuming that this court finds it legally proper, which I don't think it is, it would have to find that the defendant would have made the request at the time. So it would have to make a credibility determination. Also under case law, given how late the claim was raised, the trial court would have to find that it was still timely. And there are certain factors a court needs to consider in determining whether a request raised the day of trial should nonetheless be denied as being untimely. So it would have to make those additional legal factors as well. But as, again, turning to whether or not this court should, the trial court did, in my opinion, already make the credibility determination. Not only was that its own assessment of the witnesses, in this case, it's even stronger because it's completely buttressed by the trial record. The defendant's claim is that this disagreement happened weeks before trial because he wanted to testify it was provocation, but his attorney wanted to testify. She refused to argue provocation because she wanted to go with misidentification. That is completely belied by the fact that she moved for a continuance the day of trial to find a witness for provocation. So I think if we look at the record, it shows us that she wasn't against pursuing a defense of provocation, but because they were unable to find a witness to do so, that's why she decided to go with the defense that she did, which completely buttresses the trial court's credibility determination that the defendant was adding better claims after the fact. So I guess in addition to, I just return briefly to the legal issue of whether or not Ronquillo really was intended to apply this far. I would also just point out that I feel like this case is an extremely poor vehicle for it. The pro se claim, the defendant spoke at sentencing. He made his claims. He never once alleged that his attorney violated his right to testify. We also had the Curtis advisement in this case. I do think it bears emphasis that this pro se claim was not raised, at least based on my recollection, in the original opening or reply briefs. The first time it was raised was in the supplemental authority and then oral arguments the last time we were here. So I think all those things together make this an exceptionally poor vehicle for what I think would be both a wrong and an unprecedented holding that when defendant requests substitute counsel, a trial court has to engage in the full inquiry because we're assuming that he or she may not want an attorney, when all other case law suggests that the way we approach those inquiries is to assume that the defendant wants and should get an attorney because they're going to be better off.
But isn't it that we're not trying to make assumptions at all, and that's the purpose of having a full colloquy and explaining to the defendant what his or her options are, is we're not trying to read the defendant's mind and figure out what they want to do. That's why the whole colloquy as it's set forth in Ronquillo is, why do you want to fire your attorney? What do you want to do if you fire your attorney? These are the options you have, and then making sure that whatever decision they make is a knowing and intelligent one.
And I still think that what's the animating factor here, it isn't that the Supreme Court was concerned about whether or not the defendant's right to go pro se would be vindicated in Ronquillo. The issue was they wanted to make sure that in the case of retained counsel, should you fire your attorney and we let the attorney be terminated, that you understand the potential negative consequences that you will go pro se.
And you've said that the court wants people to have attorneys, but isn't it clear that the law also establishes that if somebody doesn't want an attorney, that they should be allowed to exercise that right? And that's as equally highly valued as having an attorney.
Well, they do have the right, but again, case law is very, very clear that the request has to be made unequivocally and timely. And in this case, just it never was made, which I also find problematic given that the facts of this case do show that we have a defendant who knows how to raise complaints when he wants to. He filed a grievance letter. And as a practical matter, I think as this court has seen, defendants who want to go pro se, they raise it. So as a practical matter, we don't need this rule because when defendants want to go pro se, they know how and they do, in fact, raise the issue timely and unequivocally. Because that wasn't done here, this court should affirm.
Well, wouldn't that depend on the knowledge and the understanding of the system that a defendant has, which would require factual findings to be made regarding that?
I'm out of time. May I answer the question?
Yes.
I would just say that there is, if that was required, I would assume that there would be some case laws generally saying that a defendant should be instructed at some point that he or she has a right to go to pro se. There is no such law. So in this case, I'm aware of no case law saying that a defendant doesn't request an attorney, but raises it for the first time on appeal that a trial court has, or that an appellate court has to send it back for further findings.
Okay, thank you.
Thank you.
All right. We used up your time just as we used, perhaps I used up primarily Mr. Lee's time in his argument as well, asking questions. So there isn't additional rebuttal time at this point. So we will take your arguments into consideration. Thank you for being well prepared and being tolerant of being responsive to the questions that we sent out ahead of time. And we will issue an opinion in due course. Let me just say, this has been a pleasure. This is my last oral argument with the Court of Appeals, so I'm glad that both of you were able to participate in that. You made very good arguments, and it was a pleasure. So thank you, and we'll be in recess.
recess, subject to call.